Senator McDougall, Senator Norment, Senator Stanley, Senator Morrissey, Senator McClellan, Senator Surville,
Here.
Senator Edwards. Mr. Chair, you have a quorum.
Thank you, Madam Clerk. So, members of the committee, the way I intend to run this docket is do D-Staff first at 7:45. Then I believe we'll do Senate Bill 411, Morrissey second, which is the drug possession cases, and the two McClellan bills. Then Edwards fifth, animal abuse sixth, and then the marijuana resentencing bills last. And then the other bills, we'll see if we get to them. We might just kick those to next week. So having said that, Senator D-Staff, Senate Bill 745. This is committee, ladies and gentlemen of the committee, this is a bill to, I guess, reinstate capital punishment for the willful and deliberate aggravated murder of a law enforcement officer.
Mr. Chair, I believe that's Senate Bill 379.
Oh, did I get the number wrong? Sorry about that.
Mr. Chair, members of the committee, thank you for having me today, Friday afternoon. I'm going to try to keep this under 2 hours and 45 minutes. So this bill, I'd like to go through a couple of details, one or two examples, and we have a couple of speakers. This bill basically says if you kill a police officer, then the death sentence is back on the table. So as we've seen over the last week, we lost two of our officers. The week before that, we saw at the national level a couple of officers go down. And every week since we've been here, we've lost an officer. Not in Virginia, but nationally. We've lost two of our own last week. And Mr. Chairman, members of the committee, just as I believe that if you punch a police officer, you should end up doing jail time, I believe that if you kill a police officer, a law enforcement professional, then the death penalty should certainly be on the table. These are the individuals who put their life at risk for folks they don't even know every single day. They step in the face of trouble every single day. When shots are fired, they don't turn and run. They turn toward the shots and address the issue every single day. So I think the least we could expect is that we would have punishment, or at least put it on the table, that if you kill a police officer, then on the table should be the fact that you'll get the death sentence. So, Mr. Chairman, we've got a couple of speakers on this, and I'd like to yield some time to them, and then we'll go from there.
Senator Stanley?
Yeah. Question to the patron. You said that they should get the death penalty. Are you saying they should be eligible for the death penalty, or they should get it? Like there's no ability for, hold on, there's no ability for a jury to determine whether the sentence would be life without parole or the death penalty?
Mr. Chairman, Senator Stanley, let me re-clarify. I think the death penalty should be back on the table as one of the potential options.
Mr. Chairman.
So,
Senator Stanley.
So then you would still leave it in the hands of the jury to make that determination?
Mr. Chairman, Senator Stanley, absolutely.
Mr. Chairman.
Senator Stanley.
And you understand, I fought to make all what we called those special circumstances murders, what we called capital murder, life without parole. You understand right now the sentence of a conviction for murdering a police officer in the Commonwealth of Virginia, even though the death penalty has been abolished, is without exception life without parole. Taking that out of the hands of the jury. Is that true?
Mr. Chairman, Senator Stanley, yes, I do understand that. I actually supported that bill.
Thank you, Mr. Chairman.
Thank you, Senator Stanley. Are there any other questions for Senator D-Staff before we go to testimony? Okay, Madam Clerk, we're going to set this at 5 minutes per side, given we're on a Friday. We have 5 more bills to do. Attorney General's office.
Yes, sir. Thank you, Chairman Surville. My name is Nicole Whitman. I'm here on behalf of the Attorney General's office, and we wholeheartedly support this bill. One of the reasons that we support the bill so fervently is because there must be the ultimate punishment for the murder, the intentional murder of a police officer. And it's not to suggest that the life of a police officer, while in most cases, and certainly in the 27 years I've prosecuted, have been nobly spent in support and in defense of the most vulnerable in our society. It's not to suggest that their lives are more precious or more valuable than anyone else's, but it is bigger than the life of those who serve in this capacity. It is a system at whole, in large, that also needs to be defended in this way and that needs to be upheld. Because if you have folks who feel that there isn't the ultimate and the highest price that could be paid for murdering someone who is the system, who is the justice system, who upholds the laws, then the system will crumble. We see that across the nation every single day, as Senator DeStefano spoke about. It is a lack of respect, not only for the individuals who are murdered in this way, these police officers, but for the system as a whole. And we wholeheartedly believe that setting the possible sentence at a maximum would help to dissuade people from committing these heinous crimes. So we do support this, and we ask that you report this bill.
Can you hold on a second? I think Senator Morrissey has a quick question
Yes, sir.
on this Friday afternoon.
I understand what time it is, Scott. What if you get it wrong? What if the person that was sentenced to die did in fact not commit the crime? If you could answer this with specificity, how do you correct that problem if you execute the person?
Well, certainly if you execute the person as it relates to that particular individual, of course, because they are deceased, there is no ability for anyone to bring them back. However, there are so many fail-safes put into place to hopefully prevent, and it has prevented on many occasions, us for society and the judicial system from getting to that point.
Next question.
Yes,
Senator Morrissey.
You talked about fail-safes, and I think what you're talking about, at one point I heard somebody say 9 sets of review after somebody is convicted in a trial court, and that includes state habeas, federal state Supreme Court, appellate process, United States court. One person I think put it correctly, 9 levels. Explain this for me. How do you explain that in the last 15 years, 204 people that were on death row, that were sentenced to die, were exonerated because of advanced DNA tests, wherein the prosecutor came back and said, we got it wrong? What about those folks?
Senator Morrissey, I would love to answer your question, but I know you want specificity. Unfortunately, I can't give it to you because I don't know the specifics of those cases. There are often times when there are changes in circumstances. There are situations that occur when prosecutors may have witnesses or may have...
No, excuse me, Mr. Chairman. I'm talking
Senator
about
Morrissey.
a situation where... Okay, well, I want my answer, I want a specific
Hold on,
answer to this question.
Senator Morrissey,
Thank you.
try and go through the chair. Senator Morrissey.
Thank you.
Next question.
I'm talking about where the prosecutor doesn't have new evidence, but they found out the person was innocent because of DNA. What do we do in that situation where it is determined conclusively the person did not commit the crime, but they were sentenced to die? What do we do?
Mr. Chairman, Senator Morrissey,
Sure.
if I may, we're specifically referring to the intentional killing of a police officer. And the cases that you're referring to, there's
That would narrow
200
it down.
and something. I believe that you're talking about something completely different. This bill only focuses on the intentional killing of a law enforcement officer. So in that narrow area, I think once you get through those 9 fail-safes, I'm almost certain that every one of the cases you're referring to, I've not reviewed all of them, but I've gone through quite a few of them. I've not seen one yet that is for the intentional killing of a law enforcement officer.
Senator DeStefano, I think it's actually the willful, deliberate, and premeditated killing of a law enforcement officer, not
Correct.
intentional. But
Correct.
in any event,
Thank you,
Senator
Mr.
Morrissey.
Chair. And I thank the witness.
Thank you. Next witness, please.
Thank you.
Thank you.
Thank you, Mr. Chairman. Wayne Huggins, representing the State Police Association. It
Good
seems
afternoon.
that every year for the last 5 years, we have discussed and debated this particular issue. So what's changed? I would suggest to you, and Senator DeStefano alluded to this, the killing of police officers in America is becoming a daily occurrence. We've seen 6 killed in New York City alone within the last month, 2 in Virginia. But I think the thing that shocks me the most is where many of these murders are occurring. Who would have ever contemplated 2 police officers being killed in Bridgewater, Virginia, or 1 police officer being killed in Big Stone Gap, Virginia? Those things are unheard of, have never happened before, and yet we're seeing them with more and more frequency. What that suggests to me is there's a growing disrespect, an absolute growing disrespect for law enforcement. And unless some very tough sanctions are put in place that will dissuade these people from doing this, we're only going to see this epidemic grow. We really appreciate your support.
Quick question, Mr. Chairman.
Senator Morrison, quick question.
First of all, Mr. Huggins, thank you for your work that you do. You've been
Thank you,
doing this
sir.
for a long time, and I think I said to you on another occasion, off the record, I appreciate the work and your advocacy. But you mentioned Big Stone Gap and
Bridgewater.
Bridgewater. But in that particular case, certainly Bridgewater, there appears to be some evidence, even a modicum of evidence, or maybe even stronger, that the person had mental health defalcations. I'm just curious, do we execute that person?
I think that would be the mitigating circumstance that might take the death penalty off the table.
All right.
It may even take life without parole off the table. It would just depend on the specific circumstances.
All right. Thank you for that. I appreciate your
Thank you,
Thank you,
Mr.
sir.
Hudgens. Thank you for what you all do every day. Next, please.
Speaking opposition.
Okay. Is there anybody else in favor? Anybody in the Zoom?
If you are in the Zoom room and wish to speak in favor of the bill, please raise your hand electronically now. Mr. Chairman, we have one speaker, Ms. Vic Nichols.
Okay. Ms. Nichols, you have 1 minute remaining.
Ms. Nichols, please unmute and begin your testimony.
They can't hear now? Yeah, just, so the committee's aware the Zoom people had audio problems earlier, but I guess we've got it fixed.
I do believe, Mr. Chairman, Senator McClellan, I do believe we have it fixed. Ms. Nichols, can you unmute and begin your testimony?
Thank you very much. Out of respect and honor for a number of police officers I know, this does need to stop. Otherwise, it's open season on them, because they'll sit here and say, "Oh, we can get parole, we can do this, we can do it." The recidivism is high. I mean, there's no reason to stop. This needs to occur. Thank you.
Thank you, Ms. Nichols. Is that it? Madam
Yeah.
Clerk?
Yes, Mr. Chairman, that is
Okay.
the last speaker.
Thanks. Let's reset the timer. All those opposed? 5 minutes, please.
Good afternoon. Dan Goldman, on behalf of Justice Forward Virginia. Prior to this role, I was the Capitol Defender for Northern Virginia and worked in that office for the last 10 years. Our office represented the last individual who was charged with murder of a law enforcement officer, and a jury returned a life verdict for that individual. Something that he requested at the outset of the case was a life imprisonment without the possibility of parole. It took 3 years and at least, I would say, $2 million in funding to get to the result where the jury, the voice of the people, returned a verdict of life without the possibility of parole. There's not been a new death sentence in Virginia that has gone to a jury or otherwise in over, I believe, 12 years now. And at least 3 of those were law enforcement murder cases. So it is not that this shouldn't be severely punished. It's not that life without a possibility of parole or a severe sentence shouldn't be available. It's that the death penalty process is unsustainable, untenable, and cannot yield the results that the senator desires or that the proponents of the bill desires. And that's been proven by juries who've been given the choice to make that decision. Thank you.
Thank you, Mr. Goldman. Next. Afternoon, Mr. Caruso.
Good afternoon, Mr. Chairman, members of the committee. Jeff Caruso with the Virginia Catholic Conference. We supported the repeal of the death penalty last year. We continue to believe that that's the appropriate policy. We have tremendous respect and honor for our law enforcement and those who commit the severest and most heinous crimes deserve a very severe sentence, but we do not think that the death penalty is the answer. Thank you.
Thank you, Mr. Caruso. Next up, please.
Mr. Chair, members of the subcommittee. My name is Salim Kalfani, and I am the Criminal Justice Reform Organizer for the Virginia Interfaith Center for Public Policy, and we oppose the bill.
Thank you, sir. Is there anybody in the Zoom room opposed?
If you are in the Zoom room and you wish to speak in opposition to this bill, please raise your hand electronically now. Mr. Chairman, we have two speakers, beginning with Valerie Slater.
Okay, Ms. Slater, we have 2.5 minutes. Go ahead, please.
Valerie Slater, representing Rise for Youth and the Virginia State Conference NAACP, and we oppose this bill.
Thank you for being brief, Ms. Slater.
Ms. Galen Kenyotin, please unmute and begin your testimony. Mr. Chairman, there appears to be a technical issue, and I do not believe she is able to speak at this moment.
Okay, yeah, she's the Virginia NAACP political chairman, I think, or something like that, yeah. All right, I don't see anybody else, so Senator DeSteph, you want to have the last word?
Mr. Chairman, just to wrap it up, again, I'm not saying that we do it in every case. I'm saying that we put the option back on the table. Power projection is a force deterrent. We have the support of the PBA, the retired law enforcement community, and many others in law enforcement. And that's what I have for you today. With that, I hope you'll see positively on this bill.
Okay, thank you, Senator DeSteph. Senator Morrissey, you have a motion or something you want to say? Or
Speak very briefly to it.
Okay,
First
Senator
of all,
Morrissey.
Thank you, Mr. Chair. Bill, thanks for bringing this bill. I think you do it out of conviction. I also want to correct myself. When I mentioned the figure before 202, I was talking about the larger population of people that had gotten the death penalty. Yours is narrow. Two things. I believe that there are people that could be sentenced to death, and you do get it wrong. Vincent Martin was one that there was some empirical evidence that they did get it wrong. I'm not going to go into the facts. Next point, I think I support our police as much as anybody, and I don't agree with any of this defund the police nonsense, and I've written and spoken about that. But when we get to the death penalty, I think it comes down to this. You either are pro-life or you're not. If you're pro-life, then you're pro-life at the inception of life and unto the very end, unless it's natural causes. There's no difference. And for that reason, Bill, Senator Stuff, I'm not going and can't support your bill.
Senator Morrissey, do you have a motion?
Motion to pass it by indefinitely.
Is there a second?
Second.
Okay, clerk will call the roll, please.
Senator Norman? No. Senator Stanley? Yes. Senator Morrissey?
Yes.
Senator McClellan? Yes. Senator Surville?
Yes.
Senator Edwards?
Yes.
Ayes 5, noes 1.
Mr. Chairman, members of the committee, thank you very much for your time today. Have a wonderful weekend.
Thank you, Senator Edwards. I just also want to make clear that the vote on the bill today does not in any way reflect upon our law enforcement. We all really appreciate and respect what they do every day and how they put themselves out there at risk. And issues, very big issue, obviously, and so it shouldn't be taken that way. Thanks.
Again, thank you very much.
Okay, next up, we have Senator Morrissey. I had your bill up second on, I think it was Senate Bill 411, drug possession.
No.
Yep. So why don't you, I don't know if you want to go up to the podium to be on camera. I don't know how to. Okay.
Mr. Chairman, members of the subcommittee, I'm here on Senate Bill 411. This bill reduces the penalty for possession of a Schedule 1 or Schedule 2 controlled substance from a Class 5 felony to a Class 1 misdemeanor, and it reduces the penalty for a Schedule 4 or 5 controlled substance from a Class 2 misdemeanor to a Class 3 misdemeanor. Now, with regard to the decriminalization of it, the purpose of this bill is to allow those individuals who have drug addictions to receive less jail time and more treatment rather than simply being punished for their addictions. Number two, it removes the possession of drugs as a barrier crime. Felony drug possessions limit people in many different ways, and it limits them in their employment opportunities, housing opportunities, schooling opportunities. Greater employment actually results in less potential for recidivism. I'm going to repeat that. The more opportunities somebody has to be employed, the less likely they will be a recidivist. I could go through the punishment and penalty length for various forms of Schedule I and Schedule II drugs and the various opioids or amphetamines, and I'll only do that if I have a question. But that's the gist of the bill, and I'll try to entertain any questions. There are a couple of speakers, Mr. Chairman, Dan Goldman and Nathan Mitchell. Maybe if you hear them first, then we could entertain questions.
Thank you, Senator Morrissey. Appreciate your brevity. I had a quick question for council. I saw in just perusing this really quick that it has some changes in there for barrier crimes, and I believe we previously adopted another bill about barrier crimes, which I believe is on third read on Monday. Senator Edwards' bill that came out of the joint study, and this gets rid of barrier crimes, whereas Senator Edwards' bill, I think, sort of keeps it and creates a process. If both bills end up passing at the end of the day, I assume they'd have to be conformed somehow, right?
Yes, Mr. Chair, provided there is a conflict, the conflict would need to be resolved. I don't know if the bills are in conflict today. I could find out if this subcommittee recommends to report on Monday if they are in conflict.
Right, I got it. Okay, Senator Morrissey, why don't we take your testimony? We'll put it 5 minutes and 5 minutes like on the last one for support and opposition.
Good afternoon. Dan Goldman for Justice for Virginia. I think this is fairly simple. Drug abuse is a public health issue, not one well addressed by the criminal legal system. Felonies create enormous costs, both in judicial criminal system and more broadly in terms of societal impact, loss of productivity. Felonies are a scarlet letter, especially in the internet age. They block people from making productive use of their lives, even after long-term recovery from addiction in many cases. People can recover from drug addiction, but felonies make that more difficult. Having a felony record makes it far more difficult, makes it more difficult to get employment, to maintain employment, to get public benefits for education, and it can be a bar to recovery. And I think we can all agree that we want addicts to recover and become productive members of society. And creating felonies out of those felony records for those people is going to make that all the more difficult. So for that reason, we would ask that you support the bill. Thank you.
Thank you, Mr. Goldman. Next up, Mr. Winetta, right?
Yes, sir. Thank you. Thank you, Mr. Chair. So Sean Winetta, on behalf of the ACLU Virginia, our more than 100,000 members, we support SB 411. Let's start with what Virginians think. 76% of Virginians support eliminating criminal penalties for minor possession and treatment and treating drug use as a health issue, according to a poll conducted last week by Mason-Dixon Polling. This support holds in western and southwestern regions of Virginia that have been hit especially hard by the drug epidemic. Prosecuting small-scale possession as a felony does not tackle the root problems of substance use disorder or drug trafficking. Researchers have found no relationship between imprisonment rates and rates of drug use, overdose deaths, or arrests for drug law violations. Instead, treating drug possession as a felony saddles everyday Virginians with criminal records that prevents them from finding stable work and housing, two key factors in reducing recidivism. This is not a war on drugs, it's the war on drug users who need treatment rather than jail time. We urge you to vote yes on SB 411. Thank you.
Thank you, Mr. Winetta. Is there anybody in support in the Zoom room?
If you're in the Zoom room and wish to speak in support of this legislation, please raise your hand electronically now. Mr. Chairman, we have no speakers in support.
Great, so we'll reset the clock. Is there anybody opposed to the bill? Not even the Attorney General. All right. Anybody in the Zoom room?
If you are in the Zoom room and wish to speak in opposition to this bill, please raise your hand electronically now. Mr. Chairman, we have no speakers.
Okay, Senator Morrissey, you want to wrap it up?
Wrap it up.
You want to ask a question? Senator Norman has a question.
No, I don't have a question. I have a comment.
Okay, Senator Norman, you want to wait for him to wrap it up? Yes, okay. So Senator Morrissey, why don't you bring us home, and then Senator Norman has something to say.
Certainly. Did you say that Senator Norman had a question?
No, he has a comment after you're done.
Oh, well, very well. I don't think that drug addiction, and that's one of the things that this bill is aimed at, to get people assistance, really hasn't affected any family. Really, it has. I have never, ever in my life used drugs. I haven't even had a cup of coffee or a cigarette, but I had a brother that died of a drug overdose, so I know how closely it affects people. I want this bill passed because I see a situation where people would get less incarceration, only 12 months, but they would be more opportunities to get work. And if they're working, then then they have a less opportunity to be an offender. I really believe that it is a win-win situation all around, and it's not simply, let's give a pass to an individual that uses a modicum residue of a Schedule I or II drug.
Thank you, Senator Morrissey. Senator Norman.
Madam Chairman, the reason I oppose the bill...
Senator Norman, I don't identify as female just yet. He said Madam Chairman, so I'm just...
Well, now you've got the beard, I shouldn't get you confused.
Yeah, sorry. So good.
Thank you, Mr. Chairman. A couple of concerns that I have is, one, as you look at it, there deals with selling and manufacturing, and individuals who are selling and manufacturing, they are in fact working. They are working. That is what they do, and many of these individuals do that for a living, and they are not necessarily addicted themselves. They are a conduit to those, that are. The other thing that causes me some concern is, and I'm just reading the summary of the bill, so if I'm incorrect, I apologize. The other thing, as I read it, is that if we have someone on the street that is in possession of controlled substance of marijuana, they have been treated in one way, but now we're going to capture individuals who may be incarcerated and treat them as the same way that they're incarcerated for some reason that they have committed and been convicted of an offense. But we're going to treat them just like the poor guy on the street. And I just have a hard time reconciling that.
Quick response, Mr.
Thank you,
Chairman.
Senator Morrissey.
This bill, and it is a lengthy bill, but it does not address people that are, Senator Norman, that are distributing or selling the drug. And if I'm wrong, I know counsel will correct me.
I apologize. I just read the summary.
How about Charles, does this pick up distribution or just possession?
Mr. Chairman, it is just possession. It does, though, pick up, as Senator Norman did say, it does change the drug possession for people in prisons, which is currently a Class 5 felony, and this would make it whatever the penalties are for reducing the penalties. So it would be misdemeanor offenses. That it does do.
Okay. Thank you, Charles. So we have a bill in front of us, no amendments. Is there any motion on the bill? Senator Morrissey,
Move to pass Senate Bill 411.
Okay. There's been a motion and a second that we recommend reporting this bill, which I don't believe needs to go to finance, right?
That is correct, Mr. Chairman.
Right, so just, it would be recommend reporting the bill to the floor. It's been seconded. All those, you want to read the roll? Why don't we do the roll? There's going to be some opposed, so why don't we do the roll?
Senator Norman? No. Senator Stanley? No. Senator Morrissey?
Yes.
Senator McClellan? No. Senator Serville?
Aye.
Senator Edwards?
Aye.
Senator Dietz?
Okay.
Ayes 5, noes 0.
No's 2, ma'am.
Noes 2, sorry.
Oh, yeah. Senator Morrissey, thank you. That's all you got for today. So next up, I have Senate Bill 475, which is Senator McClellan, counsel at first appearance.
Yes, Mr. Chair, and I'm going to take that here, if that's all right.
That's fine. I can see you on the camera.
Good. All right. Senate Bill 475 would make various changes for bail hearings, the main one being the appointment of counsel for the accused, so that we would have counsel guaranteed at the first appearance. Few rights are as fundamental to Americans as the accused right to a counsel when facing the full force of government. And yet, too often at the bail or bond hearing, at the beginning of the process, we have many people who are not afforded counsel, and if they had been afforded counsel, could have faced a very different result. Rather than going through my talking points in the interest of time, I do have an individual on the Zoom who faced this firsthand. Alan Ruthers, if we could have him tell his story, he had been detained in Henrico for 2 weeks before he was ever able to meet with an attorney.
So Senator McClellan, just so I think the committee's clear, what we're talking about is making sure people have a lawyer, like at the arraignment, like the day after
Yes.
they go to jail, so they don't have to wait around for a lawyer to be appointed and get a bond motion scheduled. And there might be somebody there to talk for them at that very first moment, right?
Yes.
Okay.
I'm sorry, he's here in person. I
Yeah, I
thought
think-
he was on Zoom, but it looks like he's here.
Senator McClellan, Senator Norman has a question for you.
Yeah.
My question to the senator is, would this anyway interfere a lot of times when individuals are arrested that they appear before a magistrate who sets a preliminary bond and then they are subsequently arraigned on it? Is this in any way going to interfere with that process?
They would have counsel at that. No, not the magistrate, no, sorry. Just the
Right.
first appearance the next day.
All right, thank you very much.
Yep. Thank you, Senator McClellan. Sir, why don't you come up and tell us your story? We put a 5-minute on support and oppose. Thanks.
Thank you, Mr. Chairman and members of the Senate. My name's Alan Brothers. When I was locked up in November 2012, I did not have any attorney or counsel at my bond hearing or my arraignment. During those times, I was asked a series of questions about work, if I could afford an attorney, and since I didn't have counsel representative of me, I was not able to answer those questions. I was informed that I would have a public defender and did not see him until about 2 or 3 months after I was locked up. It was late January, early February before I saw my public defender, and the next time I saw him was at my court date in April of 2013. Had I been granted counsel upon first appearance and received a bond, I would have been able to place all my affairs in order, put all of my possessions in property, and would have been able to find out where everything is. Because currently, I do not know where my possessions are and have been trying to work on that since August. So thank you for your time.
Thank you, sir. And
Mr. Chair.
Senator Morrissey has a question for you.
It's Alan Ruthers, is that right?
Yes.
This is important. Were you given a court-appointed attorney or were you given a public defender? Because I think you said this occurred in Henrico.
No, my court was in Bedford.
In Bedford, okay.
Yes.
Do you remember if it was court-appointed or public defender?
Public defender.
Was the follow-up question.
Senator Morrissey.
When you were arraigned, was the public defender sitting at a desk and the judge said, you'll be represented by the public defender's office, and did that person give you a card?
No.
Okay.
All right.
Thank you, sir.
Thank you.
Thank you. Did I hear another question to my right?
I was just going to
Senator
comment,
Deeds.
Mr. Chair, I was just going to comment that I would think a bill like this would work primarily in an area where you've got a public defender. And if you don't have, if that's the reaction in Bedford with the public defender.
It's actually just the opposite. This bill is targeted.
Senator Morrissey.
Thank you, Mr. Chair, excuse me. This bill is targeted where there is not a public defender's office and there are court-appointed attorneys. That's where
Okay.
it is supposed to help the most.
Thank you, Senator Morrissey.
That was done after I had a discussion with folks. In most of our public defender's office, they're sitting there in the court at the moment.
Okay. Thank you, Senator Morrissey. Let's get on with the testimony.
Okay.
No.
Hello, Chairman and esteemed members. My name is Maisie Osteen, and I'm an attorney with the Legal Aid Justice Center. To speak to your points, this bill actually would really affect everyone across the state, both in contract attorney jurisdictions and in public defender jurisdictions. In public defender jurisdictions, right now across the state, there are people staffing those days, but because the due process considerations aren't in place currently, they aren't always representing somebody at that first hearing. So sure, they might get arraigned, they might get assigned counsel, but then they're meeting with their attorney sometimes later that week, sometimes the next week, and not having the opportunity to go in front of the court that day for those freedom arguments. In contract attorney jurisdictions, it would have the same.
Can I ask a
Yes,
question?
yes.
Senator Deeds.
Isn't it true that in some cases, the public defender's office is conflicted out of the case?
Yeah, Senator Deeds, can we stop the clock really quick? Go ahead, Senator Deeds.
Well, they're conflicted out of the case because they've already represent one of the co-defendants or?
Well, conflict cases, if there's an existing conflict, that might be a unique situation if there's a direct conflict. But actually in Prince William County, and Tracy Lennox, the public defender from Prince William, who did this in a contract attorney jurisdiction and now a public defender jurisdiction, she's gotten advice, and lots of other public defenders across the state from the ethics board, that they are able to represent co-defendants in this limited short-term representation agreement. It's covered in some of the ethics opinions. I believe 1839.
Thank you. Further question, Senator Morrissey.
You know, I spoke with somebody at length in my office, and they have been you,
Yes.
about this. And here is the limited short-term situation that this bill is trying to address, and I'm still trying to wrap my head around it. It is a situation where the defendant comes before the judge either the day after being arrested or on Monday morning having been arrested over the weekend. And at that time, the person does not have an attorney. It was explained to me that this bill is to address a situation where there are meritorious reasons why that person should be granted bail, but there's nobody that can do it right then.
Yes.
And so the person in court would literally go back to the lockup, talk to him about what's your job situation, what is your criminal record, and then they come back later that day before the same judge.
Exactly.
Okay, this is the only concern that I have. So everybody now knows that's what this bill is trying to cover. I just am worried, and I want you to switch.
Yes, Senator Morrissey, is your mic on? Senator Stanley can't hear you.
Yep, I'm sorry, Bill.
It's rare, but.
I'm just concerned about too many chefs, too many, chefs in the kitchen. You give somebody an attorney to represent them in that 6, 7, 8 hour period where they come before the judge, but they also have their court-appointed or public defender attorney that represents them after that. Can you just address that narrow issue?
Yes, absolutely. And right now, the problem is there are no chefs, right? So we are, in certain situations, if the public defender's office is covering it, which those are 70% of the cases statewide, IDC has said that they will be able to absorb this, and that will be a representation situation that's slotted into their case system already. Because of the local option that's built into this bill, in rural jurisdictions, in contract attorney jurisdictions, they can set up the process that works for them. Barbara Klimaszewski is on the virtual, and she has implemented this in a statewide system in Michigan, and she's also illustrated how this can work in all of those different types of jurisdictions. And what you're saying, Senator Morrissey, the idea that somebody could represent somebody in a contract case, they could represent somebody at their first appearance, potentially that contract attorney could then handle the remainder of their representation. In other situations, it might be that a jurisdiction decides that they would have a duty day, and that would be covered by one individual, and then their case would be handled later by someone else. That type of representation happens in courtrooms across the country, across the state, very often.
Okay,
So
thank you.
it's the local option.
Got it. Let's try and keep going with the testimony here. So next up, Mr. Goldman.
Thank you, and I'll be brief. Hopefully, a couple of folks on the Zoom room will be able to get in. We know that the most negative consequences that happen in criminal cases happen to folks who are incarcerated beyond 48 hours. We know that that 48-hour window is when people begin to lose jobs, they begin to lose the ability to provide for their families, to maintain child support. That's when we know that they're going to lose education opportunities. And this is especially in economically disadvantaged and marginalized communities, the folks where it's going to be felt the most. And providing a lawyer and allowing allowing someone to be able to get out on bond or to be able to raise a successful bond argument is going to have enormous impacts, not just in the criminal legal system, but also more broadly in society, where people are going to be able to maintain productive employment. And so for that reason, we would support this bill.
Thank you, Mr. Goldman. I'm going to go next to the Zoom room. So we have 4 people in the Zoom room in 1:50. We got one more person. In favor?
On behalf of the ACLU, VA, and its 100,000 members, we support SB 47. The U.S. Supreme Court has established in Judiciary v. Gillespie County that counsel must be provided at any critical stage before trial. And because of the liberty interest of people accused of a crime at stake in their first court appearance before a judge is qualified as a critical stage that requires the presence of a lawyer. For this reason and all the reasons stated before, we support SB 475 and urge the community to vote for it. Thank you.
Thank you. Yes, sir.
Virginia Interfaith Center for Public Policy, and we support the bill.
Great. Thank you, sir. Okay, I see we had 1:13 left, and we got 8 people in the queue. So people in the queue, please be mindful of the time. You have 1:13.
Valerie Slater, please unmute and begin your testimony.
Rise for Youth and NAACP support this bill.
Thank you.
Gayleen Kenyotin, please unmute and begin your testimony, followed by Barbara Kilimowski.
My name is Gayleen Kenyotin with the Virginia State Conference, NAACP. We support this bill. We see too many cases where a person stays in jail for many months before they're being seen. Thank you.
Thank you, Gayleen. Next up.
Barbara Klimaszewski from the Michigan Indigent Defense Commission. We have implemented this in all 83 counties in Michigan. Many are very low population rural areas. Many of those areas actually have no attorneys in the county, and we have devised methods to make that work. I used to say that the court personnel like this better than anybody because it takes a huge burden off the court. But now I have to say they're number 2 because who likes it the best are jail personnel. Because having the access to an attorney alters the whole situation for somebody who's incarcerated and improves their ability to function inside the jail. So it is possible to do. It's possible to do regardless of the population or availability of lawyers. Zoom is a magic answer to a lot of this, but it can be done, and we're happy to help as much as we possibly can.
Okay, thank you, ma'am. Say hi to my Uncle Ed in Ann Arbor. Next up, Ms. Martin.
I believe that was to me, Dominique Martin.
Oh, Dominique Martin, I'm sorry.
No problem. Thank you, Mr. Senator. Mr. Chair, we support the bill.
Thank you. Ariel Ben-Yishai, go ahead.
Thanks, Ariel Ben-Yishai, Professor of Economics at William & Mary. I strongly support the bill. OES studied it and determined it would help avoid 100,000 days of jail time for people in Virginia every year. Thanks very much.
Thank you. And folks, time has expired to state your name and who you're with and support opposed. Thank you. Althea Mees.
Althea Mees, Public Defender for the City of Portsmouth, where we've been doing this sort of thing for years. I support the bill.
Thank you. Ms. Lennox, Prince William County.
Tracy Lennox, I'm the Chief Public Defender for Prince William County, and I support the bill. We did this as contract attorneys before the creation of my office.
Thank you, Ms. Lennox. Jessica Sapalio.
Thank you. Jessica Sapalio, the Williamsburg-James City County Coalition for Community Justice. We support the bill, and we effectively provide counsel at first appearance in James City County and know that it can work. Thank you very much.
Thank you. You all almost have Senator Norman surrounded here. Senator Scarborough. Ms. Scarborough, I'm sorry.
Thank you for the elevation and promotion today. Sarah Scarborough, I'm the Director of Real Life. We provide reentry and recovery housing through 12 houses, over 120 beds in Richmond, and we highly support this bill.
Thank you. Thank you. Okay, is there anybody, can you reset the timer? Is there anybody opposed to the bill?
Thank you, Mr. Chairman, members of the committee. My name is Jennifer Gilmore. I'm from the Office of the Executive Secretary. As someone mentioned, the Office of the Executive Secretary has already studied this issue, produced a report that is available on LIS and the VCC website. And the issues that we have are just the significant implementation concerns that were expressed during the work group. As people have already mentioned, in the jurisdictions that are served by a public defender, this is more easily implementable, but in jurisdictions where there is no PD office, there's a greater difficulty. Number one, in the smaller jurisdictions, they express that it will be difficult for them to have court-appointed counsel available for these, for sort of the lengthy process of arraignment conversation and then the bond motion. Some of the larger jurisdictions discuss the availability of a duty attorney. Again, smaller jurisdictions don't have the people available to sit all day in their courtrooms to be available as the duty attorney. The other issue that was raised is if an attorney is not present for appointment, then how will that attorney will the attorney be notified, and whether they'll be able to make themselves available that same day. Senator Morrissey also raised a point that I just wanted to address in the bill about too many chefs in the kitchen. As the bill is written right now, there is no option for the defendant to waive bail hearings. So if they wanted to retain counsel, there's not a provision in the bill that says they can waive a bail hearing the first day. As the bill requires, attorneys have to have a confidential space to meet with their client and have time to speak with them. Some of the issues that were brought up in our work group is that some courthouses are equipped with rooms where attorneys can speak. When I was in trial practice, at least one jurisdiction I was in had one general district court, one circuit court, one holding cell for both of those courthouses. And the only available space was a conference room that was in the courtroom, so it would create some logistical concerns. If the defendants are not transported for court, then this adds additional concerns for the local or regional jails in providing AV equipment or having a secured line to speak confidentially with the attorney. So I just want to sum up very quickly. The ability for each court to hold bail hearings on the same day is going to depend on the court's infrastructure, the number of court-appointed attorneys, the presence of a PD's office, and the jail's ability to facilitate the confidential meetings. And this is all outlined in greater detail in our report.
Just so I'm clear, the Executive Secretary's office doesn't have a position. You just wanted to make your concerns known.
Exactly.
Okay, and Senator Morrissey, I believe, has a question for you.
Yes.
I don't think anybody in this room wants to make sure that somebody can avail themselves of their Sixth Amendment rights more than me, or certainly I'm is equal to anybody. Here's what I'm concerned about. This bill is designed to capture that individual who comes before the court Monday morning in front of the judge who's arraigning everybody, and you want to get him an attorney to discuss bail right that day. I get it. What about this situation? The person comes before the court on Monday and he says, I've got money. I've retained Bill Stanley. Stanley can't come here. He's in Richmond or he's in another jurisdiction. Does that person, and normally what happens is Stanley will then file a motion, he'll bring a copy to the Commonwealth Attorney, and as soon as practical, he'll get before that judge. But under this bill, there's another attorney that steps in that day, even though he's retained Stanley, and will argue for bail. That's in front of that judge on that hour, that day. Just can you address that narrow issue?
Well, and that's exactly what I was pointing to. The bill says that the court shall hold a bail hearing that day with appointed counsel. And so that's exactly the situation that we're talking about. There's nothing in the bill that even allows the defendant to say, I don't want a bail hearing today. I've got my attorney, Bill Stanley, that's coming on Tuesday, and I want to have a bail hearing with him. There's not even that option for the defendant to waive.
Mr. Uber Chairman.
Well, I'm not an Uber chair of anything, but what I would say, following up on a point that Senator Morrissey made a little bit ago, there are some courts where you don't have a judge later in the day. You know, any rule we make has to work in Fairfax County and Highland County. Highland County has the least population of any county east of the Mississippi River. 2,300 people, 2 lawyers, one's a prosecutor, the other doesn't go to court. General District Court twice a month, juvenile court once a month, circuit court maybe once a month. When they arraign somebody, they already know that that person they try very hard to keep that person from being incarcerated, but the counsel at first appearance simply is not practical in an area like that where a lawyer would have to drive at least 45 minutes to court, and a lawyer who has one court-appointed case in Highland County is not going to drive for 45 minutes, I would argue. This bill would only make sense if it's limited to public defender areas or if you're going to pilot project it and see if it's going to work.
Mr. Chair.
First, I have a question for the Executive Secretary regarding what Senator Dees just said. I mean, I've noticed, at least in some jurisdictions, they tend to resolve some of these issues using technology with video conferencing and whatnot. I mean, is the Executive Secretary's office, I mean, I assume you all have been dealing with video conferencing in many courts across the state. Is that not a solution to what Senator Dees brought up, or what?
It certainly alleviates the problem in some jurisdictions. I will just say that some of the judges or jails that were on the work group expressed concerns that they have maybe one TV for the courtroom that's available and it's in the courtroom, or some similar circumstance. And so the issue becomes just, this is going to be on the locality to bear that cost to add additional audiovisual technology, and that's just not addressed in the bill as it stands.
Mr. Chair.
Is the Secretary, I'm sorry, Senator McClellan, one more quick question, then I'll turn it over to you. But I mean, did the Executive Secretary come up with some kind of a budget estimate on the FIS, which hasn't been reported on this yet, that would sort of specify the cost to implement it if, the state were to fund it? Well, because we have a lot of money, it seems to me this might be something the Finance Committee might be willing to provide some funding for.
I'm sorry, I didn't mean to interrupt. I believe the FIS only addresses the cost that was estimated for additional court-appointed counsel. I don't think that it addresses the additional cost for either secure telephone lines or AV equipment.
Okay, Senator McClellan.
Thank you, Mr. Chair. First, there are a couple of places in the bill where it does provide for flexibility to the locality to develop a plan that will work for that particular county. And it does have a delayed enactment to give them time to do that. The woman from Michigan can provide some more information about how they handled smaller jurisdictions that didn't have as many attorneys, sort of the situation that Senator Dees just talked about, and how they made use through Zoom or electronic means. And this bill does give the court a process to decide how they're going to handle setting up a place for that to happen.
Great, thank you, Senator McClellan. I see we have one more, and thank you for your testimony from the Executive Secretary. Mr. Hensley, I think you're up. From Albemarle, Charlottesville, I think, right?
Yes. Can you hear me?
Yes, sir.
Thank you. Jim Hensley, Albemarle County Commonwealth's attorney, speaking today on behalf of the Virginia Association of Commonwealth's Attorneys. We opposed this bill, and many comments have been made that already in this hearing. I won't repeat those. As far as the Executive Secretary's concerns about implementation, those are valid concerns, and we would cite those or reaffirm those. One additional concern that's been brought up is the existence of conflicts and the suggestion that possibly this could be workable in public defender jurisdictions. Public defenders often have conflicts, and conflicts are not all co-defendant conflicts. As the lawyers on the committee know, there are many other reasons why conflicts can exist. So implementation concern is if you have a duty public defender and the public defender office is conflicted out, then you're left with some difficulty in meeting the requirements of this statute. Senator Deed's comments relating to the difficulties in smaller and more rural jurisdictions applies both to court-appointed counsel and to prosecutors. This is a concern prosecutors have, and we oppose it for those reasons. And last, Senator Morrissey's comments about too many chefs in the kitchen. I mean, you have a situation here where you're forcing counsel on defendants who may have already retained counsel, and retained counsel can't appear at that hearing, or they may not have retained counsel, but they are in the process of retaining counsel. There are a lot of problems there. In conclusion, I would say that some of the speakers in support of this bill indicated that it is workable because they are doing it in their jurisdictions. And I think that demonstrates that this bill may not be necessary. What may be necessary is for some agency in state government to look at this as a best practice and to provide technical assistance to jurisdictions who are not doing it. to follow this best practice, which we've already seen some of the speakers say can be done without the statute, and they are doing it without the statute. Thank you.
Thank you, Mr. Hensley. Mr. Benjamin, do you have something you want to say?
Yes, Mr. Chairman, if I may. What this bill does is ensure that on the first appearance, the detained accused has counsel, period. There is no downside to that is even imaginable. What the bill does not require is that there be a bail hearing. What the bill requires is the presence of counsel, and on line 40, that the court shall consider motions relating to bail. And so here's how it works. If I am contacted over the weekend and retained for an appearance that begins on Monday, I can't be there. I might say to the client, cooperate with whatever attorney they give you. Or I might say, advise the attorney that you do not wish to make application for release today. We will make it on a later day after we have developed and amassed the necessary evidence and information. But so returning to the point is that all it does is ensure that the accused, once they are detained and make their first appearance, that they will have the presence of an attorney and the opportunity to consult with them. That is important not only to give them an opportunity to advocate for release. It's important for another reason. Very few people plan on getting arrested. They don't expect it. But suddenly they are picked up wherever they are and detained and held overnight or over a weekend, sometimes deliberately. They're arrested late on a Friday so that they cannot appear before court until Monday morning. And day in and day out, as I watch these folks making their first appearance, these days often by garbled video into the courtroom, I wonder about their situation. Do they have children that they left at home? Do they have an elderly parent, perhaps somebody suffering from dementia? Do they have a pet waiting to be fed? They have zero human contact with anyone who cares a whit in order to deal with any emergency situation that might have arisen because of this unexpected detention overnight or through a weekend. And so in addition to providing an advocate to, in appropriate circumstances, advocate for pretrial release the very first day that you have an opportunity to appear before a judge, there's that human component. It ensures that an attorney, a professional, will have a couple moments to communicate with somebody who has suddenly been deprived of their freedom and locked up in case there is an emergency, in case somebody needs to be contacted. I see zero negatives about this bill. I see nothing bad about simply assuring that someone on their first appearance has an attorney they can speak with. Thank you for the indulgence.
Mr. Chair, if I can ask.
Yeah, thank you, Mr. Benjamin. Senator McClellan, keep in mind we're 3 bills in and we got 4 left.
No, very quickly. And Mr. Benjamin, is there anything in this, or for Charles, is there anything in this bill that prohibits an individual from declining counsel at that hearing, that first hearing?
No, of course not. An individual may always decline counsel.
Okay.
The only technical amendment I would make would be on line 26, where you say an appearance. I would change that to a special limited appearance.
Okay, Senator McClellan, you want to make that motion?
Yes.
Okay, Senator McClellan's moved, Senator Deeds is second. All those in favor say aye. Aye. Anybody opposed? Yeah, that amendment's made. Okay, we now have a bill as amended in front of us. I would just also note, from my perspective, in addition to the things noted, I've seen people actually make admissions on those video appearances that if there was a lawyer sitting next to them never would have occurred, with a Commonwealth attorney sitting there writing down everything they say. And it sounds to me like this is mostly more of an implementation issue than it is a legal one from the testimony we've heard. So and it does have a year delayed enactment on it, a year and a half actually, I think. Senator Deeds, I know, has some concerns, and you do have a trip to finance where perhaps you could take care of implementation issues or funding or technology costs. I would think this might even fall under ARPA. So just note that. And having said all that, is there a motion on the bill?
I move to the bill be amended, bill that be reported as amended, recommended reported as amended.
And referred to finance. Is there a second to that? Senator McClellan, you want to second your bill? Yeah. Okay. Okay. All those in favor of the motion to report the bill as amended, recommend reporting the bill as amended and referring it to finance. All those in favor say aye.
Aye.
Anybody opposed? No. One no. Senator Deeds, where are you?
I'm abstaining.
Okay. Senator Deeds recorded as abstaining. Stanley's a no.
All right, Mr. Chair.
Hold on, Matt. The clerk has to report the vote.
You can substitute. You got substitute count.
Ayes 5, noes 1, 1 abstention.
Thank you, Madam Clerk. Senator McClellan, we're now on to Senate Bill 493, which has to do with unsolicited lewd pictures, I think.
Yes, and I have a substitute, and the substitute.
Hold on. Senator Deeds moves the substitute. Senator Edwards seconds it. All those in favor of the substitute say aye.
Aye.
Anybody opposed? No. Okay, substitute, please distribute it.
So the substitute addresses concerns with the introduced bill that were raised by RAIN, which is an organization that deals with child pornography, and the Commonwealth's attorneys. And with the substitute, I'm not aware of any opposition. But what this bill does, you may remember last year there was a bill to create a criminal penalty for unsolicited lewd pics. And let me just back up. In a way, this is the 21st century version of flashing. And has become a surprising issue, particularly among realtors whose cell phones are widely available. I've heard a number of realtors, and this is why the Realtors Associations have supported this bill, and also on certain dating apps or social media sites where individuals send unsolicited, even when someone has expressly said they don't want lewd pictures. And so listening to the testimony last year, we realized that a criminal penalty is probably not quite ready. But what this bill does is it does provide a civil penalty of actual damages or $500 for the recipient, whichever is greater, reasonable attorney fees and costs, and also allows injunctive, equitable relief, and punitive damages in the event this continues multiple times. To address concerns that this could have an unintended consequence on the prosecution of child pornography, we limited this to adults. Children receiving these pictures are already covered by federal law, but there is this loophole that if you receive one of these pictures on the day before your 17th birthday, federal law protects you. If you receive it on your 18th birthday, nothing protects you. And that is the bill. I believe there are a couple of people who want to speak in support.
Thank you, Senator McClellan. I have two questions, one probably for council. Does council think we potentially need language on this, making it clear that if you send a picture from out of state, you consent to personal jurisdiction in Virginia, to action in Virginia? I know this has moved from the criminal world to the civil world, the way it's been drafted, but I'm not sure whether the long arm statute picks that up or not. If the person's never set foot in Virginia or...
Right. Mr. Chair, we can make that amendment. That probably needs to be done.
Would that be the long arm statute, or would we stick it in here?
I'd have to consider that and to see if the long arm statute does work. If not, then we can add it in here. I would have that on Monday.
Okay, so Monday we'll figure that out.
That's an amendment in concept here.
I'm not making it. He's going to come back and advise us to whether or not we needed it in full committee, but that's one thing that's stuck out at me. Senator McClellan, the only other question I had, I think the civil approach is probably a better approach right now, and I agree with that, but one of the questions I've had about this from the beginning is, suppose you have people exchanging pictures in a relationship, then the relationship goes off the rails, then like 3-4 months later, somebody brings a lawsuit in general district court, saying, I got all these pictures, never asked for them. I mean, how do you establish consent or lack thereof if their text thread is sort of silent about it? Yeah. Yeah, the evidence, my friend?
Yeah, basically.
Yeah.
They're going to court and it's he said, she said.
Yep. That's right. That's why I asked.
That's the way these things go.
Okay. All right. We're going in it with open eyes. Is there any testimony or any questions for the patron? Okay. Is there anybody online who's in support of the bill? Let's put a timer on it, Madam Clerk.
If you're in the Zoom room and wish to speak in support of this bill, please raise your hand electronically now. Mr. Chairman, we have 3 speakers, beginning with Jennifer Gaylor.
Good afternoon, Senators. Thank you for letting me speak on this bill. I'm on the board of the National Women's Political Caucus here in Virginia, and I also have twin 17-year-old girls. I live in Stevens City in Senate District 27. It's simple and straightforward as far as I can see this. If either of my daughters were to receive one of these unsolicited and indecent nude photos on her phone today, she would have legal recourse to hold that person accountable. On November 20th, neither one of them would be able to have that option because that's when they turn 18. So I'm sure, as everyone here does, I care about their online experience. Receiving these photos that they do not ask for can be traumatizing to a recipient, especially for young people, possibly away from home for the first time at college, may not have the support or coping strategies to navigate through such an intrusive experience. We at NWPC have heard from some people that have had this happen, and it is traumatic weeks, months after the experience. It is more common than you may think. 2017 National Pew Survey found that 53% of women and 37% of men have received unsolicited lewd photos. So I do support this bill, and I recommend and hope that the committee can vote yes on reporting this out. Thank you.
Thank you.
Mr. Chair.
Senator Morrissey, do you have a question for her?
For Ms. Gaylor. Is it Ms. Gaylor?
Ms. Gaylor, are you still there?
Ms. Gaylor, you should be able
Yes.
to talk again.
Sorry. Yep. Thank you.
Ms. Gaylor?
Yes, sir.
Can you hear me?
I can.
I understand the situation of your daughter who's under 18, and then you said, but what happens after she turns 18? How can she avail herself of it? Tell me, one of the things that we have to do in the General Assembly is look at unintended consequences. So what about the situation when your daughter goes to college and she's a 3rd or 4th year student, and one of her sorority sisters sends her a picture of another male student in a state of undress? She hasn't explicitly received written permission, but one sorority sister sends a picture of another young man to her. Is she in violation of Senate Bill 493?
So what this bill, the way that it's written, it gives the recipient the option of taking further action. So it, to my understanding, and of course, I believe Senator McClellan can speak more specifically to this, but it puts the onus on the recipient. So the recipient, if they are offended, if it was a mistake, if it was just her sorority sister and she says, yes, please don't ever do that again, then, it can be handled that way. So it's not as if it's an automatic, she must take her to court or et cetera. But again, Senator McClellan can speak to that more specifically.
One final question.
Senator Morrissey, one final question.
Same situation, girl and boy, or boyfriend and girlfriend, they're adults, and they have been exchanging photos for some time. Girl and boy break up. Girl says, don't contact me again, we're done. But former boyfriend sends a picture of himself in a state of undress, as he had done previously. Can that young lady avail herself of the statute now?
As far as I understand it, yes, especially if there was an explicit, please don't ever contact me again. As the kids say, she would have the receipts, right?
Okay, thank you.
Yeah,
Thank you.
Mr. Chair.
Senator McClellan.
This does say if
Right, if they've expressly forbidden it, right?
if you've expressly forbidden it or if you have not consented to it. And I would say that if you have 2 people who were in a consensual relationship at the time the picture was sent, and text messages, social media posts, emails, even when deleted, remain and have a timestamp so that you can see when they were sent. I think that would be part of the evidentiary hearing on whether they consented or not.
All right, thank you, Senator McClellan. Let's get to Nkechi Ahime.
Yes, Mr. Chairman, Peyton Ahime. Again, thank you, and thank you, members of the committee. I am the head of Americas for Bumble Inc. Bumble Inc. was started in 2014 by our founder, Whitney Wolfe Herd, specifically due to her experience with harassment online. I'd like to state that we have a unique visibility into this type of harassment. Bumble Inc. is most known as a dating app, but we also have a social friending network, and we also have a business networking all in the same app. Because of that, we're able to observe this type of behavior, and it's being reported. We did studies that found that 1 in 3 of our own members reported that they've received one of these unsolicited lewd pics, and of that number, 96% did not want it. What I'd like to say here is that we think it's really important that we draw the line that this is not just about dating or romantic relationships. The reason why Bumble is stepping in this space as a public policy team is this is about the internet at large. We do have a gap. It is growing, and it's going to continue to growing, especially with COVID, with the amount of people that are online. As has been mentioned here, you have professional real estate business networking that depend on the internet and depend to be able to show up on the internet as a whole person and be able to try to push forward their economy and money. So I just want to flag that too. The other thing I'd really like to flag as well is that you don't want to create something that's even harder for the victim to try to find resources. So the items in here that talk about the recovery of legal costs and attorney fees are really important. Many of the victims have told us that if they have to go through a really onerous process or there are difficulty, it makes it very difficult for them to want to show up and go through the process. And that's allowing the instigators of this type of activity to continue. Again, I'm here to support Senate Bill 493, and please ask that it be passed.
Thank you. Next up in support, we have Vic Nichols. We have 1 minute and 25 seconds left.
It's Vic Nichols, and I'm in support of this bill. Thank you.
Thank you, Ms. Nichols, for being brief. Next up, anybody in the room who's not in opposition to the bill? Is anybody in the Zoom room who's in opposition to the bill?
If you're in the Zoom and you're in opposition to this bill, please raise your hand electronically now. Mr. Chairman, there are no speakers.
Thank you. Senator McClellan or Council, I had one other observation about the bill, which I think we probably need to address, which is that I note that on lines 21 and 22, the bill allows a court to grant injunctive and equitable relief, and I believe that would apply in a general district court. And the only time we allow that in GDC right now, I believe, has to do with HOA cases. So, our GDCs aren't really well set up for injunctive relief. Do we need to limit that relief to circuit court or what?
Mr. Chair, what I would just say is I know, only because we talked about this on Wednesday, FOIA cases can be brought in general district court.
Mandamus, right? Yeah.
And they can provide equitable and injunctive relief in FOIA cases.
Well, does council think it might be safer, instead of just having wide open injunctive equitable, just say they can enter an order prohibiting, enjoining the defendant from further doing it?
We can make that change, Mr. Chair.
Senator McClellan, is that okay with you?
Yes.
Okay. Does anybody have a motion to that effect?
So moved.
Senator McClellan moves it, and I think
Second.
Senator Edwards seconds. All those in favor say aye. Aye. Anybody opposed? Great. Okay. We have an amended substitute now in front of us, which I believe has to probably doesn't have to go to finance anymore as amended because you've gotten rid of all the criminal stuff. But
It never had criminal stuff. It was always a civil penalty. I don't think it has a fiscal impact.
Before it might have had.
Mr. Chair,
anyway.
before finance was requesting it, I think as amended, it may not need to go to finance, but I will check and make sure on Monday.
Okay. So in the meantime, why don't we just have a motion to report the bill, recommend reporting the bill, the substitute is amended, and
I'll make that motion.
Okay, Senator Deeds and Senator McClellan seconds, Senator Edwards thirds. All those in favor of reporting the bill as amended, say aye. Aye. Anybody opposed? No. Senator Morrissey is a no. Any other no's? Okay.
I 6, noes 1.
Great. Thank you, Madam Clerk. Next up, the bat. is Senator Edwards, Senate Bill 134, moving the age of delinquency to up to 21. Senator Edwards, why don't you present 134? I'd also just note that Mr. Qualiato flashed me a note that says we don't need to amend the jurisdictional stuff. The long arm statute picks up your bill, Senator McClellan, so we don't need to do that amendment.
Mr. Chairman, members of the committee, this bill would increase the jurisdiction of the Juvenile and Domestic Relations Court to age 21, which it was until about 1994, 95, I believe. A little bit of background. Science has taught us a lot in recent years. Harvard has been studying the brain for about 40 years. The Research Institute in Roanoke's been studying the brain. We know that people, we know where judgment is. The judgment faculties of the brain are here somewhere in the subfrontal lobe. Science understands that. And this does not mature to age 24 or 25. That's just fact of science. And
Senator Edwards, my wife thought it didn't kick in for me till I was about 35.
that's probably true. In fact, every parent will tell you that. 19-year-olds do not have maturity in terms of judgment. In fact, science has shown us that developmental science shows that if you're 16, you're pretty smart in some ways, like a computer. You're better than anybody else here in this room with computers. But when it comes to judgment, you're not there. Neuroscience and on development shows us that those under, say, 24, 25 are impulsive. They take risks. They're sensation seekers. They use peer pressures. I had clients one time, they're 19, did some really stupid stuff and said, "Why'd you do this?" "Well, I thought I had to. All my friends were doing it." And every mother and father have had this experience. And it's also true that historically, the age of majority in medieval England was 21 years. In fact, the English law and American law had 21 up until very recently. And in 1942, because of the war, they reduced the age of conscription from 21 to 18. And in 1971, the 26th Amendment reduced it to 18 for voting purposes only. But we said, well, why not? You know, you're fighting in Vietnam and so forth. You should all drink a beer when you're 18, for crying out loud. So we reduced alcohol to 18. Then it went to 19. Now it's at 21 again, because we realized people under 21 don't have the judgment that they should have. And so also, there's a federal law, I believe, Credit Card Act, prohibiting credit card. You're not subject to your credit card liability until you're 21. I believe that's right. The Affordable Care Act has a dependency coverage to age 26. And in addition to all this, there's a racial component. The kids from 18 to 21 in the juvenile court, African Americans are 1.4 times more likely to be adjudicated in a criminal matter in the general district court. So this would put people that age in the juvenile court rather than the general district court. And it's also important to know that the juvenile court system is more amenable to dealing with juveniles. In fact, for a century ago, when the juvenile court system was set up in the early 1900s, the focus was on providing services and treatment for children of that age. And so the juvenile court system has more opportunity to deal with people of that age. And also, science shows that people of that age are able to be reformed and rehabilitated and change and become better people. So the juvenile court system is set up better than the adult court system is for a whole host of reasons. And so I'll be glad to answer any questions.
Senator Edwards, looking at LIS, it appears to me there was some amendments that you were intending to propose. It looks like a couple of them were technical, and then one was to extend the effective date of the bill out to January 1 of 2024. Is that right? Would you like to offer those?
Yeah, we do have amendments here.
Okay, Senator Edwards moves the amendment. Senator Deeds second. All those in favor of the technical amendments or the amendments, say aye. Aye. Anybody opposed?
It's important to note that the bill would not go
Yep.
into effect to January
And-
of 2024.
Yep.
And so then also the provisions, it is prospective, and also nobody would be able to go back with habeas corpus and so forth.
And Senator Edwards, I also, just looking at LIS, I see something I've never seen before, which is under the impact statement, there's a racial and ethnic impact statement for this bill that was prepared by JLARC. I've
Right.
never seen this before. I guess this is a new,
That's right.
yeah, I get, yeah, it's the first time I've ever seen the actual report though, so anyway.
Yeah, so that, as I say, African-American underage people of this age are 1.4 times more likely to have cases adjudicated as a criminal offense in the General District Court and then twice as much in the Circuit Court.
Got it.
So it does have a impact, positive impact when it comes to the racial issue as well.
Thank you, Senator Edwards. Is there anybody you have here to testify in support of you're aware of?
One of the persons I talked to, and one of the juvenile court judges in Roanoke, or Salem actually, loved the bill. She thinks it's a great idea.
Okay, so is there anybody in support in the room? Anybody in support online? I see Valerie Slater's lined up. Everybody else needs to queue up. Why don't we take Ms. Slater and put a 5-minute timer on everybody?
If you would.
Valerie Slater with Rise for Youth and the NAACP. We support this bill. Specifically, I would like to note that we already have what's called the serious offender statute. That statute allows for young folks who have been adjudicated as delinquent as young as 17. They're able to stay in DJJ's care all the way up until they're 20 and a half. You know, they go back before that committing judge and every 2 years and determining whether or not they're going to remain incarcerated. So this particular piece of legislation would just bring into alignment this idea that we already know we don't want the younger folks, young folks who should take full advantage of all of the rehabilitative services that are available in DJJ. We don't want them in DOC. We want to take that time to rehabilitate them. This bill would allow all of those protections and services to apply, even those protections that allow for the expungements of records and all of those things that go away once you turn 18. They would remain in effect for those still young, impressionable, and doing some of those things that you shouldn't be doing between that 18 to 21 year range. So for all of those reasons and those that the patron has already stated, NAACP and Rise for You support this bill and hope that you will vote yes.
Thank you, Ms. Slater. Do we have anybody else in support in the Zoom?
If you're in the Zoom room, please raise your hand electronically now to speak in support. Mr. Chairman, there is no one else in support.
Okay, let's reset. Anybody in the room who opposes? Concerns, I think. Opposes or has concerns? Senator Edwards, you got somebody behind you.
Mr. Chairman, members of the committee, Alyssa Padden with the Office of the Executive Secretary. The court system actually has a position of oppose on this bill. And I want to be clear that we have no argument with Senator Edwards' policy goal. We certainly understand what the intent of the bill is. Our concern is with the impact on the juvenile and domestic relations district courts and their ability to handle their dockets. Some preliminary numbers that we've looked at, general district court case numbers for misdemeanors and felonies for defendants in this age range are over 60,000 per year statewide. So we're talking about a pretty significant shift in jurisdiction in terms of the J&DR courts. And as committee members are aware, and as I think folks have pointed out, procedures in general district court are much more time intensive for the management of these cases than they are in general districts. So when we're talking about 60,000, upwards of 60,000 cases shifting from general district to juvenile and domestic relations district court, it's actually a much more significant impact on these dockets because of the more time intensive management, more hearings. You know, we've done our best in the few weeks since this bill has been filed to try to estimate what the effects would be, how many clerks would be needed. We certainly would need to look at how many judges would be needed to handle this. And we have asked for a delayed effective date, and I understand that amendment has been made. However, I can't stand here today and tell you that I think we've necessarily accurately identified in the few weeks that we've had all of the resources that would be necessary to implement this, and that's what gives rise to our position.
Mr. Chair.
Senator Morrissey.
Would you not agree that for every individual that is transferred from General District Court to J&D Court, necessarily that's one more person for J&D Court, but one less person for the General District Court?
Yes, Mr. Chairman, Senator Morrissey, that's true. But what I would say is, while judges in General District Court can be cross-designated under certain circumstances to handle cases in General District Court, we're talking about quite a lot of support that would be needed from clerks as well. And it's not so easy for clerks who've received very different training to be diverted from General District Court to Juvenile and Domestic Relations Court to be able to handle these additional caseloads.
Follow-up question.
Senator Morrissey.
Would this person who was 18, 19, or 20 be considered a juvenile?
I believe the bill defines them as underage adults, or I may be getting the terminology wrong.
Youthful offender?
They create a separate
I think it
category.
says underage person or something like that. Yeah.
Underage person, Mr. Chair.
Yeah.
Thank you.
Final question.
Senator Morrissey.
To either council, to the committee, or Senator Edwards. We passed a law in 2020 with Senator Marsden's bill that allowed juveniles to avail themselves of parole once they have served 20 years of the sentence. Would this individual who was tried in J&D court, whether they were deemed juvenile or youthful offender, automatically now come into that population of people eligible for parole?
Mr. Chair, I'd answer Senator Morrissey with no. The provisions only apply to juveniles from the 2020 bill, not to underage persons.
Right.
Thank you.
I think that's right. The idea of having a delayed effective date is to solve some of these issues. You probably would need more juvenile judges,
Right.
but you're not going to need any more General District Court judges.
During this budget cycle. Okay, I think we still have 3 minutes in opposition. There's, I think, 2 more people to testify in the Zoom. Ms. Nichols, go ahead. 3 minutes we have left, and you have one person after you.
Thank you. At my church, 13 is the age where you can join or be an adult. So you can definitely manage things there. But when they can enlist, fight for the country, vote, you need to learn to accept responsibility at some point in your life. Most shootings occur with males in their late teens and early 20s. And last question, do we have a difference based on sex? Because we do mature before y'all. Thank you. Bye.
We do what?
Thank you, Ms. Nichols.
I'll
My
accept
wife
that.
probably agrees with you. Mr. Hensley, 2 minutes, 40 seconds.
Thank you. I'm speaking again on behalf of the Virginia Association of Commonwealth's Attorneys, and we oppose this bill. And in opposing it, we certainly acknowledge the importance of treating people in this age group differently, the youthful offenders, and appreciate Senator Edwards' efforts to provide different standards that apply to people in this age category. Prosecutors currently are empowered to treat these people differently based on the use of prosecutorial discretion. Now, with respect to the bill, there's a problem that we see that you have the jurisdiction of the juvenile court ending at age 21. And so you've added this new age group, and so some of the people in this age group are approaching the age of 21, and so the benefit to them of the rehabilitative aspects of juvenile court is going to be very limited. Somebody could be sentenced to DJJ when they're age 20 and a half and end up serving at most 6 months in DJJ. So the disposition, shrinking the possibility of real period of time during which rehabilitation could occur is a problem with this bill. Now, the point has also been made about how time-intensive juvenile court proceedings are as compared to general district court proceedings. And one particular area that I think is important to note to the committee here is transfer hearings. These underage persons in this age category are much more likely to be subject to requests for transfer, given what I just said about the limitations of the juvenile system to hold them within the system for any substantial period of time, And also due to their age, they may have other factors that establish that they would be better candidates for transfer than younger persons. And when you look at the transfer statute, there are several factors in the transfers that are affected by the age of the person. And one of these is whether the juvenile or underage person can be retained in the juvenile system long enough for effective treatment and rehabilitation. So when a request for transfer is made, that's a factor that comes into play. Also, mental and emotional maturity. So what we see is the likelihood of many, many, many more transfer hearings being instituted by prosecutors as a way to protect against some of the problems that I have referred to here. And those transfer hearings are very time consuming. They require a lot of work on the court services unit's part to do the transfer reports and separate hearings, judicial consideration of the factors leading into transfer. And then if a decision to transfer is made, the juvenile can appeal that, and it can be, again, another workload concern for circuit court. So we're in opposition to this, although certainly in support and sympathy with the goals that this is trying to achieve. It just needs a different approach, in our opinion. Thank you.
Thank you, Mr. Hensley. That's it for those in opposition. Senator Edwards, you want to wrap us up really quick? This is a really, really, really big bill that changes a lot. So,
first of all, the transfer in a serious case is to circuit court. You can certainly do that. Secondly, in the Roman era, 25 was considered a mature male, 25. And in the Marine Corps, they don't really want you if you're over, say, 22 or so. They want you when you're 17, 18, 19, 20. Why? Because they could tear you down and build you back up to do exactly what they told it to do. The military understands the difference between those who are teenagers or up to under 21 and
King
those that
Tut
are
became
older
a
than
king
that.
in Egypt at age 9, by the way, too.
What'd you say? I didn't hear you.
King Tut became a king at age 9, did he not?
Yeah, Peter the Great became a king too when he was like 9 years old or something like
There you
that. But no, the point, the military understands the difference between those who are 19, 20, 21, and 18, 17, because I can tell you, Marine Corps boot camp at Paris Allen or San Diego, they really don't want you older because you can start thinking for yourself. They can tear you down, build you back up exactly as they want you to be. They want the officers to be older so because people can think better when you're a little bit older.
okay. Thank you, Senator Edwards. Senator Deeds, you were reaching for your mic. Was there something you wanted to say?
Nothing I'm burning to say.
Okay, thank you. So we have a bill as amended, and I believe it has to go to finance. And
Move to report and re-refer.
okay, there's a motion to report, re-refer it. There's a second. Any other discussion? Doesn't sound like it. Okay, all those in favor say aye.
Aye.
Anybody opposed? No. 2 noes. Norman, Stanley, or noes?
2 noes.
Get that?
Ayes 5, noes 2.
Okay, Senator Edwards has another bill, but it doesn't have to go to finance. So we're going to try and do the last 3 bills, 2 of which go together first. So the next one is my bill, Senate Bill 249. Actually, the last 2 are mine. And so I'm going to turn this over to Senator Deeds. But we move to Senate Bill 249.
Okay, Senator Servell, tell us about the sexual abuse of animals and what you aim to do to stop, wipe this stuff out.
Thank you,
Senate Bill 249.
Yeah, let me. Okay, thank you. Thank you, Senator Deeds. So, folks, this bill is not. Oh, this is what I need. This bill, just so you all are clear, was not something I just dreamed up. This was a bill that was brought to me by the Humane Society folks, advocates in Virginia. And basically what it does is it brings our law, it makes our law consistent with the law of many other states. Like I think Kentucky was one state, and I forget there's a couple others they cited me, but our current law basically suffers from some deficiencies. It doesn't really use old language. It doesn't provide a clear definition of what constitutes sexual abuse to animals, so it has some large loopholes about what could constitute that. It doesn't penalize people who are not themselves the abuser, but those who solicit or allow others to sexually abuse their pets. It lacks references to authority and procedures such as seizure and disposition of animals. And like women and children, animals are often traded and trafficked for sex and frequently used in the pornography industry, and this is not prohibited under current law. So I would note that the sexual abuse of animals is the single strongest predictor of increased risk for committing child sexual abuse. And they've done studies, the 44,000 males evaluated for misconduct, and they found sexual contact with animals is the single largest risk factor and strongest predictor of increased risk for sexually molesting a child. And so basically what the bill does is it prohibits engaging in sexual contact with animals with any part of the body or an object, prohibits promotion, advertising, or offering animals, or soliciting animals for sex, prohibits the creation and distribution of animal pornography, requires the convicted person to refrain from contact with animals, requires psychiatric assessment and counseling, and exempts veterinary procedures, except that animal husbandry, animal care, artificial insemination, and conformatory judging, which I guess is a thing in the agriculture industry. But I know it.
Senator Serville,
Yes,
I've
sir.
got one question.
What's your one
Down
question?
the lines 32 and 33, you say that a person who does this stuff can own an animal after 5 years.
Yep.
How come? Why would you ever allow somebody who's done any of these things to an animal to have a pet again?
That was just what was suggested to me, Mr. Chairman. I'm not wedded to that, and but yeah, it's pretty disgusting stuff if you're actually convicted of it, and that's a good question. I'd be happy to strike that sentence if you like.
Well, I'm just one person. It just concerns me that you're saying that suddenly somebody who's done this stuff, like have sexual contact with an animal, is going to be all well and able to have another animal after 5 years.
Yeah, I mean, I'm not sure. I'm not a professional, psychiatric professional. I haven't read the literature, but I would think that once you've done this, you're kind of at risk in the future, just like you are with children, and you have to go through a lot of therapy to. We usually do that for, I guess, sex offenders with kids, for pretty much for life, or not.
There's nothing in here that connects us to the sex offender registry, is there?
No.
So an offender is not, an offender, maybe a serial offender, is not going to be registered as a sex offender.
That's correct. Of this, yeah.
Mr. Chair.
Senator Morrissey.
Counsel for the committee, don't we already have a law proscribing any type of sexual contact between a human and an animal under some type of bestiality statute?
There is a crimes against the nature statute, which is the section right before this, but that does not go as far as this one does for the sexual abuse of animals. It is also, the elements are a little bit different. This bill goes much further. It also deals with the filming or of animal sexual abuse. So it does go much farther than the existing laws we have.
Further question.
Senator Morrissey.
So previously, and this is addressed to counsel, a crimes against nature offense would, a crime against an animal would be covered in the criminal code, Charles or Mr. Benjamin, under a crimes against nature statute. Is that right?
That's correct.
Okay, question for the patron.
Senator Morrissey.
Did something happen in a jurisdiction where the Commonwealth attorney said, I cannot prosecute this case under a crimes against nature, the existing crimes against nature statute, I need a more specific statute? Did that occur?
Yes.
Sorry, that's somebody I think testifying on the Zoom, but Senator Morrissey, the bill was brought to me by the Humane Society actually last year, but because of the bill limit, I didn't bring it. But the way they described it to me was that, and I handed to you during the session a chart that showed a lot of specific examples of things that have occurred around the country, not necessarily in Virginia, but I know nobody's made me aware of a specific scenario in this Commonwealth, but I can tell you that this animal porn is out there, and under our current statute, there's nothing wrong with that. Or it can't be, animal porn can't be prosecuted in Virginia, either manufacturing or distribution or possession of it. And as I said earlier, if somebody who doesn't do the touching facilitates it or makes their pet or their livestock or whatever available, they suffer zero consequence. It's only the person who actually does the act
And Mr. Chair, I would just add that the current statute only prohibits any person who carnally knows in any manner any brute animal or voluntarily submits to such carnal knowledge. So if it's not carnal knowledge, it is not covered by the current statute. And there are many forms of sexual abuse that would not be considered carnal knowledge.
But that's also a Class 6 felony, right?
That is correct,
So
Mr.
we're not
Chair.
changing the penalty, we're just providing further definition here.
Exactly.
Okay, have you looked at this, Steve? What do you think?
There's people in the Zoom too.
I've been trying to figure out what a brute animal is.
Okay.
I don't know. So I looked it up. And that's not real helpful. So I think the answer is the old language, perhaps it fit, but maybe it didn't. And it's time to stop using antiquated language if we're serious about preventing disgusting sex with animals.
So you think this further defines existing law?
Absolutely.
And it doesn't create any problems?
It does not.
Okay. Senator Morrissey's got a question.
I always have thought there's some merit to, whenever we pass a law, go through the code and find one that's antiquated and get rid of it.
Yes.
Are we going to get rid of the brute animal crimes against nature statute, or do we just keep that in the books too?
Well,
Given that this is more
They're
specific.
both the same class felony. I like cleaning up the code.
Yeah.
What we would be taking out is paragraph A of the
Correct.
crimes against nature section, because paragraphs B and C
has to do
involve,
with kids.
kids and incest.
Mr. Chair, I would this is more of a technical drafting issue. If you take out subparagraph A in the crimes against nature statute, there's a lot of cross-references to subsection B. So this would go from a one-page bill to a many-page bill to cleaning up those cross-references, which is completely the prerogative of this committee.
What we can perhaps do if we decide to pass this bill is we can count on the Code Commission to come up with a clean up down the road to take out subsection A. And also, we can deal with the large bill at that time.
That's correct, Mr. Chair.
Is that all right with you, Senator Morrissey?
This would certainly be more interesting than what we normally do.
As chairman of the Code Commission, and Senator McClellan's on the Code Commission too, we could send some requests to look into this if you want to.
Okay, well, let's see if we've got people on the, we do have some people that want to speak in the room, and let's hear from the people in the room, and let's do it. Let's first see if anybody's opposed to this bill. Is there anybody in the room or anybody in the Zoom world that's opposed?
If you are opposed to this bill, please raise your hand electronically now. Mr. Chairman, there is no one in the
There's
Zoom room.
nobody. Okay, so let's do 3 minutes total. 3 minutes of why? Because I don't think the bill's in any trouble.
Okay. My name is Detective Wright. I have been an Internet Crimes Against Children investigator for the past 14 years. When I became an investigator, I did not, one of the things I knew I was going to see was child pornography, but the amount of animal crimes and animal sex abuse pictures that I was going to see is astronomical. And I can give you a very, very brief situation. I've had numerous pedophiles who I have gone to their house and executed a search warrant, and when I review their computers in the lab, there is nothing but animal abuse videos on there. The technology is really good. They know how to get rid of the child pornography. The animal abuse videos are not illegal, and they hold on to those, and so then we can do nothing as law enforcement.
As a detective, do you see any reason why these people ought to be able to own a pet after 5 years?
Are you asking my personal opinion?
Yes.
I wish them to never own a pet, ever.
Okay. Thank you. Yes, ma'am.
Thank you, Molly Armis with the Humane Society of the United States. Thank you, Senator Sturville, for bringing this bill. Just want to show our strong support. This is a very serious crime. This really does just modernize our code and really bring us up to speed with sort of the internet. To the detective's point, we are seeing more of this online, and again, just broadening it so it accounts for all types of sexual contact with animals.
Thank you, ma'am.
Thank you.
Yes, ma'am.
Mr. Chairman and members of the committee, my name is Tabitha Treelor. I'm the Director of Communications for the Richmond SPCA. The Richmond SPCA thanks Senator Sturville for introducing this bill to address the serious crime of animal sexual abuse, and we cannot understate the importance of bringing Virginia Code up to date to address how these crimes are perpetrated in the current era. And so we thank you for your consideration and hope that you will move to report. Thank you.
Thank you, ma'am. You know, I think the issue of whether a person, a person who abuses a child they're going to go on the sex offender registry, and they're going to be forbidden sometimes for the rest of their lives from being close to a child that is not theirs. I mean, I think this whole 5-year limitation on ownership is something we ought to think about. But for now, I'll entertain a motion to report and re-refer.
Well, couple points, Mr. Chair. A couple people have mentioned this 5-year limitation as being nonsensical. Why don't we address it, if you feel that strongly, why don't we address it right now?
Okay.
Okay? And I don't want to usurp the thoughts or language of the patron, but there appears to be a problem with the 5-year.
Why don't you just put a period after animal and strike for a period of up to 5 years?
It's fine. I have no objection.
The court then would have the ability to prohibit ownership forever.
So on line 33, after the word animal, strike the next 7 or 8
right.
word. Okay. I guess that would be my motion.
I'll second it.
All right. Further question.
Well,
further question, Mr. Chair.
Sure.
One of the witnesses testified about.
Can we vote on the amendment first?
Oh, yeah, I'm sorry. Excuse
Okay,
me.
we've got an amendment before us. All in favor, say aye.
Aye.
Opposed? Okay, the amendment's adopted. Senator Morrissey.
All right. One of the witnesses testified about animal abuse videos. I don't see anywhere in your bill, Senator Servo, where there's anything prescribing that. Was that intentional?
That's in there.
It publishes, produces, distributes, publishes.
What line are you working on?
I'm on line.
Line 28, yeah.
You're talking, and then you're getting down to the obscene item on page 30. So you're
All right.
producing, distributes, publishes, sells, transmits, finance, possesses with the intent to do the same. And then you're down on line 30, or an obscene item depicting a person engaged in sexual contact with an animal.
Okay, Mr. Chair, does that prescribe somebody from possessing it, but not possessing it with the intent to distribute it?
It should.
I'm looking for that
It
language.
says produces, distributes, publishes, sells, transmits, finance, possess with the intent to distribute. That's at the end of line 28 and then over to 29.
Mr. Chair, I don't want to get pandemic.
No,
pedantic
Senator
about it,
Morrissey's
but it
point
says
is well
possesses.
taken. It doesn't have just possession alone. It's only possessed with
Right.
the intent to distribute. He's right about that.
So why don't we entertain another amendment?
Okay.
On line 28, after the word finances, insert the word possesses, comma. If that is your intent.
Possesses, comma, then another comma, possesses with intent to distribute.
Well, once you have possesses, comma, then you can, that's it.
Yeah.
Okay.
I have no objection to that.
Okay.
So
Morrissey makes the motion, Servell seconds, all in favor, say aye.
Aye.
Opposed, like sign, okay. So we've amended it twice. You got anything else? Steve?
Just to make note of a detail that I think is not an important distinction for the bill's purpose, the definition of animal only applies to non-human vertebrate species.
So you're
That's
not,
the definition in the bill.
So
But I don't take it that there's any need for it to be broader.
what's
invertebrate? Worms and insects?
Worms and insects. Well, fish has a vertebrae.
Yeah.
Fish has vertebrae, but I can't, I
I don't want to go there, but
I don't
I'm
wanna
the
think about
lawyer. I'm
any of
supposed
it.
to point out these
I don't wanna think
details,
about any
so.
of it. Okay, motion to report as amended. Do I have that? And
I'll make
refer to finance.
I'll make the motion.
Okay. And is there a second to that motion?
Second.
Okay. We've got a motion to report and refer to finance. All in favor, say aye.
Aye.
Any opposed? Okay,
Ayes 5, no 0.
okay.
Thank you. Thank you, Mr. Chairman. I have the last two bills. Senator Lucas told me I could present hers, and hers needs to be rolled into mine. So I would move that Senate Bill
518.
518 be rolled into Senate Bill 745.
And Senator Lucas be listed as a chief co-patron.
Yep.
Okay, all in favor of, and is that seconded?
Yes.
Senator McClellan seconds the motion. All in favor, say aye.
Aye.
Aye. Any opposed? Okay, that motion passes.
Thank you,
Senator
Mr.
Servais.
Chairman. I have a substitute bill I'd like to offer. I'd move the substitute.
Okay. Does the substitute anticipate the first motion you made?
Yes.
Okay.
Well, no, Mr. Chairman. So the substitute was drawn to Senator Lucas's bill of 518. It can be changed in full committee to reflect the prior motion that was made.
Okay, so the motion is to adopt the substitute in concept
Or with a different number on top.
with a different number. So Senator Servais moves, Senator Edwards seconds. All in favor of adopting the substitute, say aye.
Aye.
Okay, the substitute's before you, Senator Servais.
Thank you, Mr. Chairman. So this bill takes part of Senator Lucas's bill and then part of my bill and puts them together. And basically what it does is it deals with the sentencing of people who are currently incarcerated for marijuana-related convictions. When we had the discussions last year when the governor's amendments came through for the marijuana bill, one of the issues that came up at the very end of the conversation was, what about the 400 to 500 people who are currently in prison for marijuana-related offenses? And it came up so late in the discussion, there was a little bit of discomfort with trying to attempt to deal with that in the conversation. So basically, Senator Lucas's bill basically provided for resentencing of everybody, and my bill provided for everyone being able to apply to the parole board to get their sentence modified, which is how we handled it with Fishback, which had a lower fiscal impact. And back when the Fishback, I wasn't part of the Fishback conversation, but apparently some people thought that was more streamlined. So what this bill basically does, and by the way, I think we're talking about 400 to 500 people, although there's been some question issued about that.
Not as many now as there were last year.
Right, and it shrinks every year. So, but what the bill does is it basically says anyone who is convicted of a marijuana-related offense where the only thing they were convicted of was marijuana-related, they can do a resentencing hearing in the court that they came out of. But anybody who had a marijuana-related conviction, a felony, where it was related, and they were also convicted of another felony, say, for example, like, malicious wounding or murder, or there was some kind of deal that went bad or something like that, those people would have to go to the parole board. So that's basically the approach that we took. And, therefore, both approaches will be in play as the bill moves through the process and goes over. And it's anticipated the marijuana bill would be, provisions in that, the big bill would be conformed to this in finance if this committee acts on it and the full committee acts on it favorably on Monday.
And the enactment clause does what? Three. So you wanted the.
This has to do with finding out who the people are who are locked up. And then it sets a time frame that they have to petition for their resentencing or their parole so that they can't just do it in like 2026 or something.
Okay. Well, it said they've got to do it within 60 days of receiving the electronic list, and then the provisions of the act expire on July 1, 2025.
Right.
Okay. Is there anybody in the audience or in the virtual world who needs to speak to this bill? For or against?
Mr. Chairman, we have a few speakers in the Zoom.
Okay, well, let's do 3 minutes aside, okay? Anybody who's for the bill?
Mr. Chair, I just want to say, because there may be some confusion, anyone looking for the substitute language online will be able to find it under Senate Bill 518.
Okay.
Okay.
Okay, thank you. Okay. There are three people in the virtual world who want to speak in favor of this bill. Sheba Williams is first. Ms. Williams, welcome.
Good afternoon, Chair and Committee. This is Sheba Williams with No Left Turn. I am also on the Cannabis Equity Reinvestment Board. There has been a lot of concern about the people who sit in prison as the state stands to make billions of dollars off of this industry. We know that a lot was talked about social equity and centering people who have been harmed. So we fully support the bill and the amended version of it. We need to bring these people home as soon as possible, especially in the face of where we are with cannabis legalization. Thank you for your time.
Thank you so much. Dominique Martin.
Good afternoon, Mr. Chair, members of the committee. Dominic Martin, New Virginia Majority. We're also in support. This is good restorative justice practice. It's just simple fairness and justice for those that have already had to suffer through all the ramifications of the war on drugs. So we hope you support it. Thank you.
Thank you, sir. Gayleen Kanoyton.
Hello, my name is Gayleen Kanoyton with the Virginia NAACP, and we strongly support this bill. Thank you.
Thank you, ma'am. Valerie Slater.
Valerie Slater with Rise for Youth, also NAACP, and we strongly support the bill.
Thank you, ma'am. Okay, is there anybody else in favor of the bill? Are there people that are opposed to the bill?
If you're in the Zoom room and you wish to speak in opposition to the bill, please raise your hand now. Mr. Chairman, we have one speaker, James Hingley.
Okay, Jim Hensley. Welcome, Jim.
Hello, I was just rejoining. Thank you. Virginia Association of Commonwealth Attorneys opposes this bill. First of all, there are a number of offenses that we'd ask the committee to look at carefully in terms of instituting parole or a reconsideration of sentencing. Those are listed as 18.2-255. This is distribution to minors, 18.2-255.2. Distribution or possess with intent to distribute at or near public schools. The next one is 258.02, fortified drug houses, 258.1, prescription fraud and forgery, and also delivery to prisoners. Question that the committee should consider in our estimation is whether those are offenses for which a retroactive parole ought to be considered in light of the legalization of marijuana. They involve conduct that goes beyond just marijuana possession.
Let me ask you, Jim, would the Commonwealth Attorney support the bill if we took those sections out? If we took those convictions out?
Well, I would very much hesitate to speak for all 120 Commonwealth attorneys. I would say I have another objection. I think that possibility is certainly something that would move us in the right direction. But let me address the other objection.
Okay.
And that is that, as I understand the bill, you are going to have, under the substitute, I hope I have the right substitute, I think I do, the provisions of this article shall apply to any person convicted of a felony and not serving a sentence for an act of violence. So this would be nonviolent felonies who may have had a sentence enhanced because of a felony conviction under all of these provisions, and that lists the list of provisions. And so I think what that opens the door to is when it says have a sentence enhanced, in any case where you have been convicted of a felony and an associated marijuana felony, that in the course of sentencing, in the preparation of the sentencing guidelines, your previous conviction of a marijuana-related offense would add points to your sentencing guidelines, and therefore would be seen under this provision, I believe, as enhancing your felony conviction for a non-violent, non-marijuana-related offense. And that possibility certainly opens the door to potentially a huge number of people for reconsideration. And I think a number was given at the beginning of this hearing that was a finite number, fairly small, but I think under the interpretation of this section of the substitute bill, I think that number could be considerably larger, as well as opening the door to reconsideration of other offenses in which the marijuana one, which is what you're trying to get at here, getting reconsideration for people who are convicted of marijuana-related offenses, I think you're really expanding the scope of this way beyond what the intention of this statute is.
Okay, thank you. I'm
Just
sorry.
quickly, the statute refers to 18.2, 248, and 18.2, 250 as being ones where it could be used for sentence enhancement. Both 18.2, 248, and 18.250 are not marijuana statutes, so we question why those are included in this provision. Thank you.
Okay, thank you, Jim. Senator Servell, do you want to respond to anything that's been said?
Mr. Chairman, first of all, it says with regard to 248 and 250, on line 15, it says, as it relates to marijuana. So I'm not really clear, and I'm not sure whether he's looking at the substitute or not, but I'm not clear where the association thinks.
Well, I'm not sure if you saw that either. I'm not sure if you saw.
Because that even it also says that on lines, he's talking about the enhancement language. It says on lines 28 and 29, felony conviction is enhanced because of felony conviction under this as it relates to marijuana.
Right.
So,
I'm not sure if you saw that. What about his reference to the code sections that deal with sales to children and sales near schools and delivery to jails and what do you say about all that?
well, Mr. Chairman, I would say that this doesn't require these people to get lower sentences. It only allows a court to look at it, the circumstances, and you could have an 18-year-old who sold to a 17-year-old near a school that could have been brought up as part of this, which is very different than some 40-year-old doing it. And I think these are factors to be taken into account, I guess. But he's correct that those people would be eligible to be looked at.
But the point you're making is that there's nothing in this code section that says that even though they have a right to petition for resentencing, there's nothing in here that requires a court to resentence.
No, there's nothing that requires a new sentence to be issued by the judge
Okay.
after considering all the facts and circumstances. And certainly I would think if somebody is still in jail today for some of these things, by the time we get to 2022, that would be a pretty significant sentence. And I would think it would have been pretty significant conduct that led them to still be in prison for that.
Are there members who have questions? If not, is there a motion on the bill? It's Senate Bill 745. It's a substitute form that includes 518 with Senator Servell and Senator Lucas as chief co-patrons. Okay, and
I'll second that.
Okay, motion's been made and seconded to report and to recommend reporting and re-refer to finance. All in favor, say aye.
Aye.
Mr. Chair, I think that's your docket, isn't it?
Well, I had one more on the docket that Senator Edwards said, why don't we just take it up now? He thought it'd be pretty easy, which was Senate Bill 137, which has to do with requiring a judge to explain a deviation from the sentencing guidelines.
Yeah, Senate Bill, I'll just say here if that's okay. Senate Bill 137 relates to discretionary sentencing guidelines, a written explanation, and appeals. It provides that the court should make a written explanation that adequately explains the sentence imposed to promote fair sentencing. In addition, there's an amendment I'd like to add that Charles has.
Right. Mr. Chair, I have, there are
Mr. Quaglio, is this the amendment we discussed last week?
It's essentially that amendment. Basically, the amendments, there's three amendments. The first one is after the F on line 41, it is insert a court's ruling on a defendant's objection to the calculation of the discretionary sentencing guidelines is reviewable on appeal. And then the next two are on line 43 after imposed, strike may and insert shall. And then on line 43 after the or, insert may be. And the effect of these amendments are basically stating that if a defense counsel objects to the calculation of guidelines, that will be reviewable on appeal. Currently, right now, there is no mechanism for even I'll say a miscalculated guideline to be reviewable on appeal. The second two provide that if there is a deviation from the procedures regarding the calculation of guidelines, that shall be reviewable on appeal, and it may be the basis of other habeas relief or other subsequent post-conviction relief. Those were the amendments.
Mr. Quiet, I had a question. So, I guess when we were talking about this bill, preparing for today, I pointed out that at least when it comes to child custody cases, if a judge fails to articulate their consideration of the factors, the way the statute's worded for child custody, it's pretty much de facto error. And I thought that the best approach to this would be the same kind of thing, so that if a judge failed to articulate the basis for deviating, that would be sort of a pretty clear error situation. I mean, with these amendments, does this do that?
Mr. Chairman, this is sentencing in criminal cases only.
I get it.
Correct.
But I want to make sure that the Court of Appeals has a clear message from us that we expect the judges to put this in writing, and they're not going to say harmless error, who cares?
Mr. Chair, I would say that the way the bill is currently written, that would it is appealable, and it would appear to be error. I do not know, though, if the Court of Appeals would say the failure to do that is not still an abuse of discretion. I will take a further look this weekend to see if we can flesh that out. Steve's looking at, with wide eyes, too.
Steve?
Yeah, it's one thing to make it reviewable on appeal, but once the appellate court gets it and they see that there's no adequate explanation, I don't know what the standard of review is.
Mr. Chairman, right now, the judges have wide discretion. We have sentencing guidelines, and they can, they don't have to be, not stuck with the guidelines, but they can go up or down, but they ought to at least explain themselves. I'll give you one example. I had a case sometime over 10 years ago. I didn't try the case, but I did handle the sentencing. The jury at that case recommended 10 years. The jury recommended 10 years, and the guidelines were 3 years, roughly. And the judge just said, well, the jury recommended 10 years. I'm going with the 10 years. There's no explanation at all, despite psychiatric testimony, despite the guidelines, despite the pre-sentence investigation report. And all the judge wrote down was the jury recommended it, period, end of story. And the judge can explain himself. As long as he can explain himself, it makes some rational sense. And there's such a thing as abuse of discretion. It's a doctrine of law. So that can be, the appellate courts can deal with that.
Mr. Chair, as I read this,
Senator Deeds.
on lines 22 and 23, and Steve, I want you to react to this. The written explanation shall adequately explain the sentence imposed to promote fair sentencing. If there's no written explanation, or if it doesn't adequately explain, how is that not reversible error?
If that's the committee's intent, then we should say so.
Okay.
Otherwise, for example, the response from the Commonwealth will be, it's harmless error.
So, Mr. Benjamin or Qualiato, one of you guys, I mean, I'm looking right now at the custody statute, and I know that the way it's been interpreted by the Court of Appeals in the custody statute is the failure to articulate is clear error, and it's always reversed and remanded for the court to articulate its reasons. I've only ever seen it written in the code that something is reversible error under 30-5 of the code. That's the only place I remember seeing that. I'm wondering if what we're talking about might be better for an enactment clause as opposed to code language, given how the code's been drafted, but...
Needs to be, what you want to happen needs to be in the code.
Well,
So if you would like to say that failure to provide that is reversible error, Steve, I can come up with something and present it have it on Monday. Because I did look at the support guidelines and I didn't find what you're, the idea you're referring to in the code, which is why I didn't put it in the amendments.
What I was referring to, if you look at 124.3 in the last paragraph, it says the judge shall communicate to the parties the basis of the decision either orally or in writing. And and that's been interpreted by the Court of Appeals to be error every time if the judge doesn't do it, and they send it back and tell them.
Well, again, this is, Mr. Chairman, this is criminal. It's not the same as, domestic relations issues. It's just, the judge needs to explain himself, and he can explain himself and make sense, then the Court of Appeals can affirm.
I get it, Senator, but my point is that if they don't do it, and the Court of Appeals gets it, and they say, doesn't matter, harmless error, then the judges aren't going to change their behavior. Which is what you're trying to address. And so my only point is the Court of Appeals has looked at this situation in custody cases, and they reverse it every time and send it back. And so I thought perhaps the custody statute might provide a good analog to get the kind of conduct we're expecting, and that's why I brought that up. But
the appellate court does not want to be put in the position of being a sentencing court. And so I'm thinking as we talk, which is dangerous, it should be remanded to the sentencing court. But I think if Charles and I think about this over the weekend, we might be able to fashion something more intelligible than that.
Okay.
All right.
All right. That was just my concern. I wanted to make sure Senator Edwards' bill actually achieved what he was trying to
So we
achieve.
adopt an amendment in concept?
Well, yeah.
Yeah, we've already adopted the
I think you
amendment.
should adopt the 3 amendments you probably have in front of you,
Okay.
and there'll be a 4th amendment in concept.
Okay. All
Okay.
right.
I move that we adopt these amendments, these 3 amendments, and then a 4th amendment
Contemplating the
conceptually,
standard of review.
in a block.
All right, okay.
Sorry, I keep forgetting I'm now back being chairman. All those in favor say aye.
Aye.
Anybody opposed? No. Okay, the amendments are adopted, and along with the amendment in concept that's coming. Okay. Is there anybody to speak in favor of the bill?
If you're in the Zoom room and wish to speak in favor of the bill, please raise your hand.
Or opposed,
electronically
raise your
now.
hand too. This room's emptying out.
I do believe we have one individual to speak in opposition, James Hingley. Sorry.
Mr. Hensley, go ahead. No, we don't need a timer. He'll be quick. Jim, we're not going to put a timer on you, but you're our last bill.
Sorry, I was just joining the room. All right. Yeah, quickly, our concern, which I think you have addressed, is that it's not clear what the standard review is and what the appellate court does after it's decided the case. And I think you're going to address that. But even so, the Virginia Association of Commonwealth Attorneys opposes this bill because what you're trying to accomplish here is to get trial judges to adequately state the grounds for departure from the sentencing guidelines. And this is going to generate a lot of appellate litigation and put the Court of Appeals in the position of having to develop a jurisprudence of what constitutes an adequate explanation. In the end, what you will be accomplishing, it seems, is enforcing some kind of discipline on your trial judges to get them to do a better job. But you're not going to be changing the outcome of cases if, when the case comes back, the judge offers a more adequate explanation. Adequate explanation as an issue on appeal is something that can be endlessly litigated. I don't think there's any defendant who would not take advantage of the opportunity to question whether an explanation given is adequate or not. Perhaps there is some other way to accomplish the goal, which is getting the trial judges to do the right thing. Thank you.
Thank you, Mr. Hensley. Anybody else in support or opposition? Okay. You want to speak?
Farrar Owens, I'm the director of the Virginia Criminal Sentencing Commission. We oversee the sentencing guidelines. The commission takes no position on the bill. We are here to answer any questions you might have regarding our procedures and policies related to departure reasons.
Okay, thank you. Okay, I don't see anybody else looking to testify. Is there a motion on the bill? Then a motion to report, refer the bill. Oh, no, not refer the bill, just report the bill. All those in favor say aye. Anybody opposed? No. Okay, the committee will rise. Thank you, everybody.